be a very simple but never promises to be session of discussions of settlement. And we're going to structure this meeting quite simply. We're going to discuss High Court Rule 34 and its mirror submissions in Magistrates Court Rules 18. Then we're going to move on to a Calderbank offer. And then we're going to talk a bit about making a settlement agreement in order of court, the negotiations of settlement, and the consequences of a settlement agreement. Each of these aspects are completely different from one another and cannot be passed off as the same or similar. Let's first and foremost start off with High Court Rule 34 and Magistrates Court Rule 18, as I believe these are the simplest aspects to make. Now, they mirror each other similarly, but I encourage each and every person here to go and consider the rules individually. When you consider a rule in respect of settlement, it must be read exactly as it is stated. Go and read Rule 34, go and read Rule 18. You need to understand these rules, the implications and timelines, as well as how binding they are on a party. That is of critical importance when you're discussing settlement. You need to have an appreciation for the binding nature of that settlement. It does not flow well if you say, okay, I'm willing to settle, but only if it suits me and only on terms that suit me, and irrespective of what the other party says. You will never have a settlement in those aspects. Now, that being said, Rule 34 and Rule 18 allow a party to make a settlement, an offer of settlement on a with prejudice basis to the opponent, which is brought to the attention of the judge from that moment going forward. I'm going to work mostly with High Court Rule 34 because it is the rule with which I'm most familiar, as I've not dealt with the Magistrates Court rules in about 7 years. Now, Rule 34, a party will generally issue a notice and say, let's use a delictual example for insurance. Sanlam issues a tender of 75% on liability with a tender for costs limited to a party and party scale. So this immediately puts your opponent at risk. And the beauty of this is it either ends litigation or it provides a half indemnity for the costs which are incurred on a party and party scale beyond that point. It is very beneficial to anyone engaging in litigation to consider making an offer, as it ends that aspect of litigation and renders a court essentially dies inducio, or re judicata as the SCA would have it. This is the best thing you could consider. The common law considers the settlement of a matter as nothing more salutary. It is the best thing a litigant can do when it comes to litigation. Even better than settling it before it becomes a lawsuit, because then why are we here? That being said, we are going to then move on to a Calderbank offer, which is very similar to a Rule 34 or Rule 18 offer, save that it is consequent more punitively in respect of costs than what a Rule 34 or Rule 18 offer would be. A Calderbank offer may not be brought to the attention of a judge under any circumstances until the conclusion of a trial or the application, whichever your matter relates to. Now, the beauty of a Calderbank offer is it is inter partes until that final moment. You are able to give it to your opponent and they are immediately placed at risk of settling for anything less or anything more has an implication of costs. Now, Calderbank is quite recent in our case law and it dates approximately to 2017, if I'm not mistaken, where it was accepted by the Northwest High Court and then subsequently by the Western Cape High Court. In my practice, I often use a Calderbank offer to short-circuit litigation and to place the defendant at extreme risk for punitive costs. Now, I say this having chosen my words very carefully. A Calderbank offer puts one's point. Yes, Bruce?
Good day, everybody. I'm Bruce Barkhazen, notary and attorney. I would actually like to, sorry, Ian, I hope you don't mind me chiming in. I would
That's
like to
fine.
mention that something that's very important and actually quite notable about Calderbank offers is they tend to mimic the procedures set out in Rule 34 or 18, as the case may be. So, as far as humanly possible, you would need to comply with those requirements. Think of you trying to comply with the rules, but for going the full 9 yards. For instance, instead of it being the defendant who makes the without prejudice or the with prejudice or the conditional or unconditional offer to settle, it could be, for instance, the plaintiff. So that's just something to bear in mind. You do need to comply with the rules in order for it to be a true Calderbank, as far as I understand, if I'm not mistaken, Ian.
Bruce, you are quite correct. And it must also conform with the common law as well as the constitutional law. And these aspects can be seen in the matter of Eck versus Pearson. And I will get to that in a moment, as it sets out a number of specificities which an offer or an order must comply with. Forgive my enunciations, please. So coming back to the punitive aspects, before I regale myself to the formal compliances, is once a Calderbank offer has been made, it places the other party at great risk for punitive costs against them. If we use the example of the insurance matter, where an offer is made for 75%, if at trial 75% or higher is proven in respect of liability, then the person opposing this trial is liable for attorney and client costs. It might not sound like much, but if one considers the difference in party and party and attorney and client being party and party is what is reasonably necessary and is the basic costs of bringing a matter to trial, versus attorney and client is basically all the work you have done, which falls under a party and party ambit, but it is not limited to the aspect of what is reasonably necessarily required. It is far more beneficial for your client and actually for yourselves when taxing the matter, when considering the percentiles placed on drawing fees and attendance fees, to ensure that you get the best possible court costs order in favor of your client. Now, circling back to formal requirements, it must be a formal notice on note or formal offer on notice form, which must be physically, alternatively, and electronically served, but must not be filed. The order of the proposal must be binding, must be clear and succinct, and it must not be contrary to public policy. I'm not going to spend a lot of time on the formal requirements. The case law is clear, and I believe that everyone is able to consider the Eck versus Pearson's matter. It's a constitutional court case, which has been referenced in quite a number of matters. And I would truly implore on everyone, whether you are plaintiff, a defendant, applicant or respondent, appellant or respondent, to consider using a Calderbank scenario. It is a very effective way to end litigation. Your client will become a repeat customer because you are able to save them fees as opposed to going full 9 yards to trial. Or alternatively, you are able to recoup sufficient funds and reimburse this client for funds given out in lieu of fees. You're going to be viewed as a much more effective practitioner and a much better practitioner for considering settlement. This is a separate aspect when it comes to mediation, arbitration, or alternative dispute resolutions, and that will form the basis of a future engagement or a future session, as I believe that mediation and alternative dispute resolution cannot be dealt with in such a truncated matter as in 25 or 30 minutes. It deserves a sufficient address and it deserves sufficient questioning. While I'm on the topic of questioning, I encourage everyone to submit questions in the chat of the meeting, and I'll be happy to answer as far as possible. And I'll be very happy to address any and all questions. At the end of my presentation, I'm going to deal with a very recent case from the Supreme Court of Appeal, which my firm actually dealt with, and we had resounding success in that the full bench agreed with our submissions, and we got a full bench judgment in our favor, specifically in respect of settlement and settlement agreements, as well as offer and acceptance outside of the premise of Rule 34 and Rule 18. Okay, then next would be my submissions on negotiations of a settlement. To enter into negotiations, you need to understand your case. You need to understand the law surrounding your case. You need to understand what are your strengths as a practitioner, whether legal or candidate or advocate, as well as you need to understand the capabilities of your opponent. It is all good and well to have a very good case. Poor counsel and poor representations can mess it up tenfold, and you can lose your case based on poor preparation or poor counsel. And I say counsel referring to both attorneys and advocates, as I believe there is very little distinction with someone who has rights of appearance. At the end of the day, it comes down to experience and presentation. So, once having understood your facts of your case as well as the legal arguments to be made, you are then fully aware and in the coalface of your facts of your matter. You're then able to effectively engage in negotiations. Now, this can be done in a number of ways. You can use an offer in terms of Rule 34, Rule 18, or you can make a Calderbank offer. Alternatively, you can use a round table. Now, engaging in a round table is far more effective as you get results near immediately. If the opponent's client is there, they can leave the room for a minute and come back and say yes or no, or this is the position. You are able to truncate your aspects and your issues in dispute and delineate the list to such a degree that instead of spending 5 or 10 days at trial, you can spend an afternoon in court. Most advocates will not like this, but at the end of the day, your client's interests are of paramount importance, and it is your duty as a legal practitioner to offer a service which is effective and cost-effective simultaneously. So, having engaged in settlement negotiations, you're then able to determine what is still in dispute. And this becomes very important to consider if we use again the liability aspect. Yes,
Right,
Chelsea?
you're doing like a little webinar on settlement.
Serious?
Yeah.
I can study with him. If you get him,
I accept that that was probably a mistake. No problems, no harm, no foul. So if we use the aspect in respect of liability of the insurance matter, you can take the entire matter from who was driving, what was the speed, what were the conditions, and you can dispose of those aspects, and you can surround the issues entirely into, for example, if the person was making a right-hand turn. Was it safe? What was the speed? What were the conditions at that moment, and was it safe? You have taken the issues in dispute because of negotiations of settlement, and you have refined the issues for trial. A judge will also look at this and will consider your submissions, and will more often than not consider the aspects which have been settled between the parties as a great assistance to the court, as the court no longer has to pay as much heed to these items. And this ties into the Supreme Court of Appeal case, which we'll get to in a few moments. Now, something I want to just make everyone entirely aware of. The consequence of a settlement on you and your client. It is binding. Once you have settled the matter and it is in writing, it is done. The cause of action has been demolished and it has been replaced by the contract. Yes, settlement is contract law. It cannot be forgotten. The principles of contract law are applicable, and if there is not compliance with the principles of contract, there can be no valid settlement. This must be borne in mind. You cannot approach settlement mala fide, and you must be ad idem. One moment, please.
Well, thank you, Ian, for that. I will be jumping in to briefly assist Ian. Further to the consequences, something you need to be aware of is that failure to give credence to the core of negotiating for a settlement could actually incur liability on your part as a practitioner. Think, should you negotiate in bad faith and it can be proven, you could be potentially reported to the Legal Practice Council. In addition to that, also bear in mind that the failure to investigate the possibility of settling the matter is outright a contravention of your duties as a legal practitioner. You need to investigate whether it's possible, and if so, advise your client accordingly. The courts have time and time again made various rulings that the legal practitioners ought to have attempted to settle the matter. And in fact, no doubt, as Ian will mention, in RAF matters especially, the court bemoans the fact that a number of the matters are settled on the steps of the court. And this is a recurring event, and it is still carrying on. Now, I see Michelle's asked a question, but acting bona fide is not a validity requirement for a contract. Yes, that may be so. However, there are certain representations, warranties, and guarantees that are often expressed during negotiations and could actually affect the validity of the contract. Think of misrepresentation as to enforceability of certain obligations, i.e., the house is still in good condition. Let's settle that I'll just reduce the sales price by X amount. Suddenly, if that is not true, I have made a misrepresentation, and hence the bona fide requirements out the window and the contract can be attacked. And this often happens, truth be told. I hope that answers your question, Michelle. It's not merely bona fide, but rather you may not obviously deceive your opponent, hence speaking to bona fide rather than malfide. Now, as for another consequence, sorry Ian, I'll stop in a moment. Another consequence that you need to bear in mind is that of late, as Ian will discuss in a few minutes, the courts no longer have judicial oversight in respect of settlement agreements. And hence, the settlement agreement needs to be deliberate. The language used in the settlement agreement needs to be deliberate and precise. Be warned, imprecise language is an invitation for disaster. Sorry about that, Ian.
It's not a problem. What I also wanted to peg onto and build onto what you've said, Bruce, is when discussing settlement and engaging into settlement negotiations, one has to be steeped in mandate. You cannot walk into a room and try and settle a matter and then say, oh, but I have to speak to my client first. It doesn't work like this. It's mala fide. You will get a reputation for as being a time waster. And at the end of the day, what must also be remembered, and there is a deluge of case law to this effect, a client is bound by the actions, representations, as well as misrepresentations made by the legal practitioner. I cannot stress this enough. If you make a representation that you have mandate to settle, the other practitioner need not ask anything further and may proceed as such. If you walk into that room and say to your opponent, I'm sitting here in good faith, I do not have mandate to settle, I have mandate to discuss and engage in without prejudice discussions which may lead and facilitate settlement. This may, and I'll say that again, may be seen as more acceptable, as you are still, as a legal practitioner, trying to delineate the issues in dispute. That being said, it's a risky business to say, I have to get mandate. Get it first and then get on with settlement. You cannot do anything else other than make sure you have mandate to act properly. Moving on to the consequences of settlement. As Bruce quite rightly pointed out, you are bound by settlement. The courts, insofar as they say they do not have jurisdiction over settlement agreements, it's a very wide interpretation, but a very narrow meaning. Now, the reason I say that is the court is well within their rights to examine a settlement agreement, but they are not within their rights to interfere with settlement agreements. As one can consider the Mpumalanga division, they have directives out which say that they have the authority to consider whether a settlement reached inter partes is above board and proper. Now, what this actually means is, was it obtained by fraudulent means, or was there a bona fide settlement which is within the knowledge of both parties as well as their clients? This does not interfere with the terms of settlement, but rather the settlement itself. The terms of settlement are re judicatia. The court cannot interfere in respect of the terms of settlement. That has become settled law by the Supreme Court of Appeal, as well as the Constitutional Court, but to not as more specific degree as what was dealt with by the Supreme Court of Appeal. So the consequences are self-explanatory. The terms which you set out must comply with contractual law, as well as must be within the interests of public. You cannot say, we settle the agreement, we settle the matter, and I will cut off my arm because of it. That is against public policy, to use a very simple and narrow-minded example. A clear example of settlement is, I agree to pay 50 Rand in respect of damages, as well as general damages, if applicable, in full and final settlement for having broken your pen. That is an example of a clear, concise, bona fide principle and settlement. You cannot be anything else than clear, concise, bona fide, and it must be capable of being binding and enforceable. Again, the principles of contract are applicable to settlement. You cannot have a proper settlement without the full and proper compliance with the principles of law of contract. Now, moving on to the Supreme Court of Appeal case to which I refer, I just want to quickly get the citation because I believe it will be quite helpful to the majority of our viewers. Okay, it's 1, 2, 3, 4, 5 cases into one, which was heard simultaneously. And the general citation is then going to, well, the neutral citation is the Road Accident Fund versus Taylor and others matters. And citation of case numbers 1136 to 1140. And this dealt specifically with where a settlement agreement was presented by one party to another, the acceptance thereof, and the consequences of that acceptance. So in this aspect, an offer of settlement was presented to the plaintiffs, which was then accepted. The one matter presented at the Supreme Court of Appeal dealt with the judge not willing to accept the terms of settlement, and dealt specifically with the judgment in manners which she was not allowed to. Now, I'm going to paraphrase the matter simply as she dealt with aspects and issued judgments in respect of points where she had no authority to issue such findings. She acted ultra vires, and it's very specific that I choose those words by a judge. I have a lot of respect for the bench, and I have a lot of respect for the practitioners. Good afternoon, Counsel. I see you are muted, Counsel.
Good afternoon, how are you doing?
Good, thanks yourself, Counsel.
I'm good, sorry, I'm a bit late. I just got in from court now.
Okay, great stuff. Thank you for joining us. We appreciate it. We're actually busy discussing the recent case, the Road Accident Fund versus Taylor and other matters.
Okay.
Yeah.
So again, this is why I've given the citation, and this is why the citation is listed in the chat, which I invite everyone to take a copy of and go and read this judgment. It is not only useful for delict, it is useful for contract, it is useful for the presentation of evidence, and it is useful in terms of the Laws of Evidence Amendment Act. By inference, not directly, it must be said. But this case, in a nutshell, dealt with an offer and an acceptance of that offer and its binding nature on the parties, as well as the power of a court to interfere with the terms of settlement. The Supreme Court of Appeal held by a full bench, no minority judgment, that a court is not entitled, empowered, or does not even have the judicial authority to interfere with the terms of settlement where it conforms to the principles set out in Ack versus Pearson, and thereafter they are only able to determine the terms surrounding a settlement, i.e. having it made an order of court. Now, every division of court has a different interpretation of how an offer may be presented. A favorite of many divisions is a Rule 41.4 application, which is essentially where a party has made an offer, the offer has been accepted, and then the terms of settlement are reneged on, or there is no compliance, whereafter a practitioner may apply to have the settlement agreement made an order of court, whereafter there may be execution by way of warrant or writ, as the case may be. I'd like to end my presentation with a word of warning. Do not enter settlement negotiations lightheartedly. If you are not fully cloaked in mandate as well as the facts and law relating to your matter, do not enter into settlement negotiations. You will do yourself a disservice and you will attract negative references. At the end of the day, you have a brand to protect. Your name is your brand. Your name is your reputation. You will start networking with your brand and your reputation. If you are an excellent advocate, your name will spread like wildfire. If you are a poor representative, your name will spread like wildfire. If you are referred to the Legal Practice Council, your name will spread like wildfire. Your reputation is everything. Make sure you protect it. Ahmed, I see you have asked a question. Is a court obliged to make a settlement an order of court? Isn't it entitled to decline to do so? Yes. A court is not a rubber stamp. It will never be a rubber stamp, and it can never be thought to be a rubber stamp. A court must, however, give reasons why it can refuse or decline to make a settlement agreement an order of court, and a court will not likely refuse a settlement agreement to be made an order of court. If it is within the public interest or the greater interest of the parties, a settlement agreement will most likely be made an order of court. I'd invite counsel as well as my learned colleague to make submissions in this regard. Thank you.
I agree fully with you. Even the Taylor case even speaks about that the courts have discretion, and it's not a discretion which they would fetter easily. Now, there was another question from a viewer that sent it to me by WhatsApp. The question goes: if a attorney refuses to settle and negotiate a settlement, even after a court orders them to engage in settlement and to reasonably consider all aspects, and they outright refused and proceeded to continue to launch yet another aspect of litigation, the third in 2 years, and after a rescission was granted as well, I suppose, what should one argue at trial in this regard with what has been discussed today? Counsel, what are your thoughts on the matter? Sorry, I picked the moment that you were drinking.
So sorry, man. You put me a bit off guard because I just got back from court, so I'm trying to catch up here. But you know what? With regards to the previous query that was asked with regards to court as discretion, the court always has discretion in all matters. Circumstances change, and obviously the judges change, and it depends if you're getting a different judge on a matter, then but regardless of that, the question with regards to discretion, the court always has discretion over a matter. If your case or your grounds is strong and you defend a case to the best of your ability and you believe that you have strong grounds, and I do suggest, sometimes when you get a pleading or a summons, try and nitpick everything. That's what I do. I go through every single thing and see what this one is saying, what the plaintiff's saying, what the defendant is saying, what are the grounds, what are the prospects, how you can help your client, and that is how you build your case as a defense. And therefore, if you, for example, if you don't have good prospects of success and you feel the court is not going to be in your favor, if your defense is strong, the court always has discretion. Those things happen very much in maintenance matters, especially. Like, for example, I don't want to discuss my case I had today. It was a maintenance matter, and the court was in my favor in this matter where actually I don't want to give too much detail in this matter because it's going for trial now, but the court always has discretion. That if you're asking me for advice, I would just say always have a strong case, you build a strong case by building a defense in your matter, and you always do research on case law, on what happened in previous cases, and that is how you can tackle that.
Thank you so much, counsel. Ian, I saw your hand went up as well. And Microsoft Teams is having fun with us, it would appear.
Yeah.
My apology, everybody. But in reference to the question that I mentioned earlier, that's in the chat box, typically it would depend on which court you are. In that the High Court has the power to regulate its own processes and procedures before it. So you could potentially, and now I'm not going to say this is going to work, but you could potentially bring an application to have the opponent declared a vexatious litigant. Right? That is becoming a lot more prevalent these days, especially with the abuse of process on the incline. So that's an option. Another option is to seek a punitive cost order and even try and get a cost of bonus appropriate cost order in order to sanction the attorney's conduct for advising their client to bring hopeless cases, and that's what comes to immediately to mind. Counsel, I'm going to post the question again in the chat.
I do apologies. I do need to run. I do apologize. Thank you everyone for having my presentation. Have a wonderful day, and I wish the best to everyone. As always, enjoy practice. It does not enjoy us, but we must enjoy it. Bye.
Thank you very much, Ian. So, Counsel, are you still there?
Yeah. The question, yes, I'm here. I'm just reading the question. Question from viewer: If an attorney refuses to settle and negotiate a settlement, even after a court order, then to engage in settlement and to reasonably consider all aspects, and they outright refuse to proceed to continue to launch yet. You know what? I'm just gonna read the first part. Let me answer part by part. Firstly, there are circumstances where how do I say this? There are circumstances where sometimes the attorney doesn't agree with counsel in what they actually want or what advice they're giving, and you can't say the one is right over the other. You can't point fingers like that. But what I'm trying to say is an attorney can't refuse to settle and negotiate a settlement. That is unethical. Firstly, that part is unethical. Why the person that's giving this question, why would you say that? Why did the attorney refuse? Was it because the attorney gave advice in saying maybe there's a better settlement, or I don't agree with that? So we should never pinpoint fingers at our colleagues, but rather ask why, because it's important to ask why, and that right there, the first part is not right. I don't know. We don't know the whole story, but from what I can read here, an attorney can't refuse. That part is wrong. Let me just see what else is here. And they outright refuse to proceed to continue yet another aspect. What do you mean by they outright refuse to proceed to continue to launch yet another aspect of litigation? Why did they refuse?
Sorry, counsel, I believe that okay, I've just received another message. The viewer says they refused until a court even got frustrated with them. So it would seem that the opposition's client was disinclined to settle the matter, which could be the case. Unfortunately, it's impossible. There's nothing in our law that enables you to force the opposition to settle. That's an absolute impossibility. And this is a contract, and I'll be honest with you, that contract might be problematic in itself if that is the case. But no court can order people to settle. All right. Now, with that in mind, we must, as counsel was mentioning, you should avoid attributing the actions of the attorney to, the attorney's instructions as being the actions of the attorney. In other words, remember, we are merely creatures of instruction. We act on instructions from our clients. If our client says don't settle, under no circumstances settle, unfortunately that's the case, and you can't settle then. Again, as Ian said and counsel said, you need instructions to settle. Settling without instructions is a very dangerous path to take, and I would advise you to avoid doing so.
And point fingers at your colleagues, because you need to get to the crux of why they, if you feel that you don't know why they're saying that, then ask them why and make sure you have it in writing so that it doesn't backfire at a later stage.
So
but it's unethical if the court, if the court was getting frustrated and that's waste of costs as well. That is unethical, but you should ask why. I wouldn't from that statement made, I think it's not vague, but rather ask why you're refusing.
Yeah, I understand the court ordered the parties to engage in settlements, but the court can't order them to settle.
Unless it's made by the parties, and then an
Yes.
order is put on that behalf.
Yes. What I have often done in order to smooth the negotiations is I would call my colleague and say, listen, this is a without prejudice phone call. In fact, it's regarded as having never happened in the first place. This is merely colleague to colleague talking to each other to understand what's happening behind the scenes, so that if your client really does not want to settle, I can actually literally tell my client, listen, let's not waste money on proposing a settlement. Or if they say, listen, they want everything they're asking for in the summons or the application, then at least we know where are the starting points when it comes to negotiating. So I definitely could recommend making those phone calls. Again, without prejudice. Often I use the phrase so-called, I can't even remember, but nevertheless, I'd make it very apparent that it's as if the call didn't take place. It's merely to help our respective clients meet each other. I've found that has worked wonders. In fact, years ago when I used to do a lot of protection orders, I used to do exactly that. And I would speak to my colleague, again, colleague to colleague, say, listen, I understand you're going to tell me X, Y, and Z, and I'm going to tell you X, Y, and Z, fair enough. I'm not going to repeat what you've told me. I trust you won't repeat what I'm about to tell you. And then you talk. Yes, you can't disclose anything that's subject to attorney-client privilege, unless your client has advised you can, but I encourage you to make those phone calls. Again, it builds up a sense of camaraderie in the profession, and also opens doors that would have otherwise remained closed. So I see we received a few more messages. They refuse to give reasons and refuse to counter offer. I am interested in the aspect stated today that it's unethical to not engage in settlement talks. Now, this actually emanates from case law in the realm of RAF. And in particular, there was a famous case where the attorney did not investigate whether or not settlement was possible. And this was brought to the attention of the court, and at the point of arguing costs, might I add. And the court took a very dim view of the attorney outright ignoring the RAF's pleas to settle, strangely enough. And the court was of the opinion that the proposed settlement offer and what the attorney was seeking was more or less the same, and hence there was a lot of time wasted, and it seems to have merely been an effort at gouging as much fees as humanly possible. And the court actually, in the citation of the court case escapes me, but the court did say that attorneys are, when acting in the best interest of their client, obligated to investigate the possibility of settlement, and if the settlement is in client's best interest, to advise client, and even if it's not, to advise client. Again, remember, you're a legal practitioner. Our clients come to us because we have certain expertise, and we need to look after them we need to act in their best interest, be it settlement or advising against settlement. And hence, the duty to investigate the possibility of settlement emanated from that. So that's just something I want you to all bear in mind. As for what you can do, counsel, what could somebody do where the other party is being utterly vexed, bringing pointless and fruitless applications? And we've all been in situations where our client had the right, but it was by no means easy. Think of foreclosure applications or eviction applications or the like. It's never easy to get those orders, and more often than not, the opposition is based on speculative grounds and even strange imaginings, to put it mildly. Counsel?
There's a situation that I had recently, where I was referred a matter by an attorney. I was instructed a matter by an attorney because the previous counsel that was working on the matter, um, did injustice to the matter, and apparently, you know, I don't want to speak bad of colleagues, but apparently what happened was the counsel overcharged the client or the attorney, um, and also gave incorrect advice, rather, by saying, you have to draft this, I have to draft that. And when the advocate was instructed to draft it, after saying you need to draft all these things, then the advocate said afterwards, oh no, I made a mistake, I shouldn't have drafted it, or you know what, it wasn't necessary. Now, in circumstances like these, where it's vexatious and it's frivolous, a lot of times, there are legal practitioners out there that do these kind of things, which is unethical, and they do it. Why? Because they want money. You're in a profession where you're supposed to act, where you are fit and proper, and you're supposed to act accordingly to the best of your knowledge and to the best of your ability to try and help amicably to resolve a situation for your client. And that doesn't mean that you must be vexatious in what you do, and I am totally against that. And in circumstances like that, if you feel that what you did, what the next person did was completely wrong, you should report them to the LPC, because there will be a disciplinary hearing, and they will get attended to, and eventually those queries will come up. But don't just leave it there. But in this profession, you have to be very cautious of how you deal with clients, and not take on a brief or an instruction or a client that you cannot assist, that you cannot assist. Then don't take it on. Rather give it to someone else than taking it on and then catching on nonsense. And a lot of times what happens is, and I'm not pointing fingers at anyone, but I've noticed this many times, where papers were drafted very poorly. Then I get the papers, I come to court, and then how must I argue? You're not allowed to bring new evidence when pleadings is closed, meaning when papers have been filed, you cannot bring new evidence to the court. Then you have to ask leave of the court, and you have to state why you bring new evidence to the court. And circumstances like that, you should rather, if you feel you don't know the situation, rather get advice from someone than having someone to report you being vexatious. That is my personal opinion, and I've experienced that.
Absolutely, I couldn't agree more with you. Again, I like what you said, that you shouldn't ridicule your opponent. I also, when I'm drafting papers, I also try to avoid overly judgmental language. Again, my opponent might not know better. He might actually be looking at things from a different perspective, and when you look at it from that perspective, it makes sense to go about the way he did things. So that's just something you bear in mind. That being said, remember, if you're in the high courts, you can approach the court to regulate its own process. I'm not saying it's an easy one to achieve, but it's definitely possible. I've seen Joburg High Court, for instance, people are now bringing applications to dismiss applications, and they are being rather successful, because often, especially in cases of foreclosures, the property owner would bring an application for this or that, non-compliance with section 129 of the NCA, non-compliance with this. It's unbelievable, the sort of applications, how creative they are, I must be honest. All hopeless, but nevertheless. And now the banks have realized that they can actually ask the court to say, whoa, this is an outright abuse of process. Court, can you please step in here and give some sort of assistance? One, justice needs to be heard and seen. And justice delayed is justice denied. Often that does actually produce some sort of result. Now I see there's a nice, interesting question that was posted into the chat box. Client made an offer and also signed this offer of settlement agreement after numerous offers back and forth to end litigation. Opponent made a counter offer. On the same day, client accepted the counter offer. The opponent sent agreement signed by his client, signed a few days earlier. Opponent decided to withdraw. How do you withdraw an accepted counter offer? Opponent decided to withdraw counter offer. Reason: it was done without prejudice. I do not know why the opponent's client made a better counter offer than what client offered. Now client refuses, I suppose your client refuses to continue with the settlement agreement as the counter offer was better. Any advice? So, Liesel, I'd very much like to know, was the offer that your client made also accepted? I do not see that from the question, but once you accept a settlement offer, even if it's marked without prejudice, even if it's on the letterhead, once it's accepted, it's you cannot withdraw. It's irrevocable almost. There are exceptions to the rule, but once it has been accepted,
I agree with you. Once it's accepted, you can't. But if it's not accepted, a settlement agreement is not. You can make a counter offer.
Yeah, absolutely. And if your client, let's see, now client refuses, you can enforce the counter offer, provided that the offer made by your client has not been accepted. If it has been accepted, depending on the language of the agreements, I suppose they could be construed as amending each other, depending which was signed and when. That's getting a little bit complicated. So it'll be entirely dependent on time frames, language of the agreements, and so forth. But if it has not been signed, that being the offer proposed by your client, I would immediately withdraw that offer, and then I could approach the courts to enforce the counter offer that has been accepted. So that is something that's definitely possible. Counsel, your thoughts?
I agree with you on that, absolutely. No, I agree.
So as Ian and counsel have pointed out, you cannot, and please do not try, it's embarrassing, do not try and withdraw an accepted offer. It's just not possible. It's just like
the same amount again, and you might just lose, yeah.
Also, the same applies with tenders. Once you make a tender and the opposition accepts it, same story. It's done. So bear that in mind. A few of my colleagues, a few of my opponents have learned exactly what are the consequences of a tender being accepted, and unfortunately that is what it is. But bear that in mind, guys. Be very careful with the language you use. Again, we are also wordsmiths when we're representing our clients. So before we close up, does anybody have any further questions? Feel free to put up your hands or unmute yourselves or post messages in the chat box. Counsel, while we give everybody a chance, do you have any closing remarks? It would seem we've lost counsel.
No, I'm here. I'm just thinking.
Sorry, didn't mean to put your.
Very a condensed topic today, and that was really good. But I think it's also very important that you be a bit cautious in what you say or what you do, or don't make assumptions about fellow colleagues. And if they're doing something wrong and you feel they really are, then rather ask why, but make sure you have it in writing. And if you feel they're doing anything unethically, report them to the LPC.
Absolutely. Remember,
No, you don't want to lose a client either.
Yes, but remember that this is our profession. If we leave the bad apples in our profession, our profession will become full of bad apples at the end of the day. So where it's justified, report unethical conduct to the LPC. That being said, I see that we are a bit pressed for time. We've wildly run over time, but that was a very interesting session. I'd like to thank Council and as well as Ian, even though he's not here. Thank you, everybody. I appreciate you joining our session. We look forward to holding further and more enlightening sessions in the future. Thank you so much.
Thank you very much.
Thank you all. Bye.